Thank you, Mr. Speaker. HJR 7111 is the court reform bill, and we have gone through a very deliberative and thoughtful process as we have debated and considered and worked on court reform. Members in the Civil Justice Subcommittee, I have to say we had a lot of very helpful, very in-depth debate on what are some very important and complex issues. We did a total of what were 4 workshops on the court reform issues in civil justice, and there were 9 different times that either in civil justice or in judiciary that a court reform measure was debated, discussed, and voted on. We listened throughout the process, and I tried to make a point at every single stop, Mr. Speaker, and certainly in civil justice, to say that, look, anyone who has an idea, who has a concern, or wants to just provide input on the issue, that I had an open door policy, and I invited everyone to come and talk to me about their concerns, their ideas. And many people did. Many people came and spoke to me about the idea of the measures that we were bringing forward, the court reform, and they ran the gamut. I had attorneys, I had members of the public, judges, everybody eventually came and discussed court reform, their ideas, and we listened, and we responded. And as a result, in judiciary, we made some significant amendments to the court reform bill. Mr. Speaker, the court has struggled over the years to understand and to fully grasp its role in procedural rulemaking. The court itself and many members of the judiciary have reiterated that procedural rulemaking is like the twilight zone. And that twilight zone, that's not my term. Members, that's the court term. That's the justice's term. They called it like operating in the twilight zone. And that's because they are forced to try to figure out what the difference is on a specific rule between
Representative Eisnaugle for the introduction of the bill.
Thank you, Mr. Speaker. So what we've done is originally we had rulemaking, adopting the federal model. What we've done is we've scaled that back to a provision that allows the rulemaking to stay with the court, but gives the legislature a role. We originally had 2 Supreme Courts. In this bill, we have 1 Supreme Court with 2 divisions. In the original bill, we had JQC that with records open to the entire public. There was a concern about a chilling effect. We now have taken care of that, and those records are only available to the House. We've also added 2 provisions in judiciary, a funding mechanism to make sure the court has stable funding, and then also a provision to expand jurisdiction. Mr. Speaker, that is the bill.